Hey, it's Andy Gross from the Law of Sandra P. Gross. I'm a VA accredited attorney practicing veterans disability benefits law and other veteran law topics. And today I want to talk a little bit about something we're seeing, doing a little video series on common issues that are coming up that I'm seeing in my practice and that get discussed amongst other VA benefits attorneys. And one of the most common things we're seeing when it relates to TDIU, or total disability based on individual unemployability, again, there's another video on that, is this TDIU rating that you get. Now, as I say in that video, as I note, and I've noted elsewhere, TDIU, or total disability based on individual unemployability, is not a claim. You heard that right, and I'll say it again. It's not a claim. You don't file a claim for TDIU. What's supposed to happen is that the VA identifies the issue of TDIU based on your ratings and based on the records in the evidence in the claims file itself. They go, he's unemployed, she's unemployed, and they're disabled. They're supposed to connect the dots. If the numbers reach that 70% threshold or 60% threshold, or even lower, they're supposed to send it to the Director of Compensation Services. That's a whole different topic. We're seeing the VA just miss this, right? And the VA may be saying, well, we could have considered TDIU, but we didn't even consider it because it wasn't raised because the veteran didn't file a claim. That's wrong. That is so wrong. That's not a veteran-friendly system. That's not a veteran-friendly approach, right? There's a case on point, and I discussed this in detail in another video, Rice v. Shinseki, right? This is not something you have to ask for. Now, as I mentioned in my other videos, it's a good idea to submit that 8940 form ahead of time that says you're unemployed. It's called the Application for Increased Compensation Based on Individual Unemployability. It's not really an application, though. It does let the VA, it does trigger the VA, hopefully, to let them know, like, hey, I'm supposed to evaluate for TDIU. But if the VA sees that you are unemployed, and there's enough evidence in the file to go, yeah, it might be because of the disabilities, they're supposed to evaluate that. And they're actually supposed to send out that 8940 form to you and say, hey, veteran, please send this back to us with the information we're asking for. And also, please send this other form to your last employer so that we can get more information from them about why you left, right? I've seen this come up so many times. It's like the VA doesn't even realize Rice v. Shinseki exists. It's in the manual. Rice v. Shinseki is discussed in the M21 manual, which is their Bible for how they evaluate and adjudicate claims, but they're still not doing it. So what do we do as veterans to make sure that the claims are getting properly adjudicated? Well, if you believe that if you're out of work and you're unemployable because of your service-connected disabilities, it's a good idea to just preemptively file that 8940, the VA form 8940, right? That should trigger them to develop the claim for TDIU if they haven't done so already. Let your claimant pension examiners know that you are unemployed. If you are going to the VA for health care, let them know that you are unemployed. You can even just write a letter to the VA accompanying your claim saying, hey, VA, my back condition, PTSD, whatever conditions you have, they are causing me to be unable to work. That will get the process kick-started, even though they should have started the process a while ago, on evaluating you for TDIU. Now, I've also mentioned effective dates, talk about effective dates. Because the VA is supposed to know this and trigger this under Rice v. Shinseki, it actually sets the effective date differently. So your effective date may be even before you've taken that step of saying, no, VA, examine me for TDIU. That gets really complicated. So if your effective date is wrong, you think the VA knew about your unemployment earlier, you might have an appeal for your effective date. That's one. Two, if you've been denied TDIU, it's worthwhile appealing, because what we'll often see is some random claimant pensioner examiner will go, yeah, this person can work in any job, right? And meanwhile, the person has, the veteran has arthritis in every joint in their body from that's service connected, and is 70% rated, 80% rated, but hands are arthritic, knees are arthritic, back is arthritic, but the claimant pension examiner says, yeah, no restrictions, they're good to work. We see bad claimant pension exams on this all the time. So if you believe that your service-connected conditions are making it impossible for you to hold down substantially gainful employment, appeal. File that form. If you get denied, appeal it. If you need help with your appeal, if you want to, if you're just fed up and struggling with your rating decisions, with your VA disability benefits, and you want help with the appeals, reach out to us. Hit like or subscribe on these videos. I'm going to keep producing content on veterans topics and to help demystify and educate veterans on VA disability and other veterans information that's out there. Anyway, until next time, hope to hear from you. Take care.